How do you open probate? I'm Claire from the Yanowitz Law Firm, where we've been helping families with wills, trusts, and probate for the last 29 years. And I'm starting a three-part series here where I'm going to talk to you all about the probate process. And so in this first video, we're going to talk about how to get the ball rolling with probate, how to start the probate process. And so I view the first part of probate as just wanting to get someone appointed to be in charge of collecting the deceased person's assets. So how do we do that? We need to first create a petition where we essentially ask the court to set a hearing date so that we can get someone appointed. And in that petition, we have to disclose various pieces of information. And so the beginning of this process starts with a lot of information collecting. We need to know names and addresses of family members of the person who died. We need to know names and addresses of people listed in the will, if they had a will. We need to know names and addresses of creditors. Did they owe anyone at death? Anything like mortgage, credit card, anything else that would be in the form of debt. And then we also need to get a handle of what assets did this person have? Because in the probate petition, there's an inventory section where we have to kind of outline what they owned, not in a very micro it's more of a macro form, but we need to get a sense for that. And sometimes that's kind of a catch-22 because institutions will say, well, I'm not going to tell you anything about the account because you haven't been appointed yet by a court. And so sometimes people are in a little bit of a befuddlement on getting this information, but we just try and do our best and then indicate that in the court petition. So once that petition is prepared, I provide it to my client. They can actually e-sign it. So if people want to e-sign, we give it to them so they can e-sign. And then we file it with the court. And then the court writes back and tells us what day our hearing is going to be. And it's usually 2 to 3 months after the petition is submitted. And after we get notice of when the hearing is going to be, we have to provide notice to what's called interested persons that hearing is going to occur. We have to tell people about this hearing. So what's legally required is we're supposed to publish notice in the newspaper that the hearing is going to happen. And we have to provide notice through the mail to any of the creditors, to family members, to people listed in the will that this hearing is going to occur. We also have to give notice to the Minnesota Department of Human Services as well. So that's a government agency that, like, if someone was on medical assistance, they would write back and say that there might be a medical assistance lien on the estate if the person was on medical assistance. So that's kind of the process to get the ball rolling, to have that court hearing. And then once that court hearing happens, the judge will review all the paperwork, make sure things are in order. During the hearing, they'll give it's a public hearing. So if someone wants to contest who is being appointed to act, who wants to contest the executor, someone can stand up and say that they contest it. But if no one contests it and the paperwork is in good order, then likely the judge will sign the order and what's called letters testamentary or letters of administration. And those are the documents that are needed to appoint someone with the power to start collecting assets in the deceased person's name. So in the second part of this probate 3-part series, I'm going to talk about what happens next after the hearing. So stay tuned. And if you enjoyed this video, subscribe to our YouTube channel so you can learn more about the probate process. Thank you.